Our next speaker is Helen Slottje, is a public interest attorney with the nonprofit law firm Community Environmental Defense Council, Incorporated. She works with municipalities and community groups trying to protect themselves from the negative impacts of fracking and volume of wells slated for New York towns that lie above the Marcellus shale. She also advises students at Cornell's Water and Land Clinic. Helen.
So hi, thank you guys for all coming out tonight. What a great crowd on such a terrible topic. So I am here to sort of talk about two things. One, what does the SGEIS say about local control? And two, sort of some background on commenting, reasons to comment, how to comment, and that. So it's sort of divided into two parts. So the first question is, what does, sort of where are we on local regulation of the industry? And everyone has heard, and I probably could repeat this without even looking, but there is presently in the Environmental Conservation Statute a limitation on the ability of local municipalities to regulate the industry. And we agree, everyone agrees, that's what the statute says. What the question has been is, in a Bill Clinton way, sort of, well, what's a regulation? And so, and the answer there has been that that a regulation is not necessarily the operation and a regulation is something that relates to the operation and process of a gas drilling company versus local land use and other police power laws. And the governments in the state of New York do have the power under the municipal home rule law to enact laws that relate to the protection and enhancement of the physical and visual environment for zoning purposes, to reduce traffic and the like. So the question is, are these local laws, are those really a regulation of the industry? And in fact, the courts in New York have historically found that land use laws of general applicability addressed at land use, environmental comprehensive planning, things like that, are not regulations of an industry, that they'll have an incidental impact on that industry, but that if you're not trying to tell whether it's a 7-Eleven on the hours that they can operate or how somebody has to be licensed for a group home, if you have regular zoning laws that say not in this neighborhood or not here, not there, perhaps not anywhere, that those are not regulations of the industry. And the closest analog to the drilling statute is the mining statute, which now reads differently. It's been amended, but originally read very closely, tracked what the environmental conservation language in the oil and gas context looks like. And the Court of Appeals, which in New York is the highest court, specifically said that local laws, in that case relating to the extractive industry, did not include zoning. So, and based on this sort of interpretation that you can have local land use laws, police power laws, laws that are not addressed at trying to regulate hydrofracking in particular, or how deep someone can drill, or with what sort of equipment, but if instead you have a general prohibition, as you do in any town that at least has zoning, that you can't build, there's a number of things where I live in Ithaca that I can't build, like let alone heavy industry. If I want to put a shed in my backyard, I have to go ask somebody about it. So based on that, there's been a lot of communities, and you saw from Karen's maps earlier, across the state, communities that are working on prohibitions, bans, moratoriums, and the like. And this has caught the attention of the DEC. And so they have come out, and originally in the first version of this, the beta version, they did not address local government power at all. In fact, they said, we're not even going to tell you when we issue a permit. It's totally up to you to figure this out, and we have no interest in even communicating with our local governments. So here they've now said, well, we're going to require, at least on your permit application, that you look to see whether or not your permit is consistent with the local land use planning, and you have to tell us if it's not, and we're at least going to pay some attention to trying to come up with some mitigation factors. In fact, in other cases, again, in the mining context, and I think in an injection well context, the courts have told the DEC that they can't get involved in local permitting controls. So there have been cases where the DEC, in fact, did not want to issue a permit based on a conflict with local laws, and the person seeking the permit has gone to court, and the courts have said, look, like, you issue your permits based on your laws and the state law, and then let the other people fight it out with the town about zoning. And so, and that's generally the rule in New York. So the DEC presently really doesn't have the power to refuse to issue a gas drilling permit on a conflict with local laws. So in our opinion, this is really the best that the DEC could say, is that we're going to look at it and we'll let you, we'll try to come up with some impacts. And they've gone on to say that they understand that that there's likely to be that these sort of local bans are going to result in court decisions and legal action to make for this to become ultimately clear what the home rule powers are of the towns. So as Tony was pointing out, our local bans have reached the status of mitigation measures. They assume that the timing and the issuance of permits, at least in some communities, will be slowed by fights over these local bans. So, and it seems relatively clear that they're not planning. Some people had been concerned about the DEC getting in the middle of this fight, and it looks like they've decided they're not going to get in the middle of it, at least presently, that they're going to leave it to the drilling companies and the communities to fight this one out. So I then went through, and this will be, most of this is for purposes of people looking at this later, but I've gone through and put in here every sort of quote about the local government's roles that are presently in the SGEIS, and the little section number are the section numbers from the SGEIS. So they're continuing to plan on being lead agency because, as the statute says, they're the ones that are responsible for regulating the industry. They are, again, going to require the identification of the location of the well pad and other information in this EAF about the local zoning or comprehensive plan issues. They are, and some of the other things that we've been suggesting to communities that they look at when they consider bans on gas drilling type activities, heavy industrial activities, is the issue of waste disposal. And in the new version of the SGEIS, they again note that there is the ability of persons to dispose of these drill cuttings in regular landfills, and there are cases in New York presently where these are being beneficially distributed on farmlands as fertilizer and soil and the like. So the DEC continues to not be involved in that, but that is an area where local governments can prohibit these because there's powers under the ECL to continue. Municipalities have the right to regulate and prohibit solid waste. So as long as they're not calling this hazardous waste, they're not treating it in a more restrictive sense, communities actually have the power to make it illegal to dispose of these kind of wastes in their town. So similarly, there's the concern, there was talk before about what were we going to do with all this wastewater, that private facilities were going to have to be built for this. Presently, the SGEIS considers that a speedy stormwater permit and the waste tracking is really going to mitigate any problems that one might have having a wastewater transfer treatment site located in your town. So again, these are the SGEIS, the DEC is not regulating these facilities. That leaves them open for local regulation and prohibition. So this is just another quote out of the SGEIS where they talk, some communities think, well, can we impose some kind of permitting fee? Can we require bonds? Is there anything we can do to try to get some money up front from the government, from these gas drilling companies? And the answer to that is no. The environmental conservation law specifically prohibits that, and this part of the SGEIS cites that requirement. So this is the part of the SGEIS that requires the local government notification, although it's only of an application. And there, as we've seen, there's presently applications that are stacked up at the DEC. So they're not agreeing to notify you when the well permit's issued, when fracking is going to commence and the like, but they are going to at least notify communities when an application comes in. So the upshot of all that is that the DEC seems to be, they're obviously aware of the local ban activities that has sort of gotten their attention. They are continuing to, their original position, which is correct, that localities cannot regulate industry, and leaving open and supporting the idea that communities do have the ability, or are not prohibited per the DEC's interpretation of this from going ahead and instituting local bans. So that's sort of the upshot of where the local government angle plays out in the SGEIS. So a lot better than it was before, and really from looking at it from, personally I'd like to see it be a much stronger statement, but legally this is as strong as the DEC can really come out on this. So we were very happy with this teeny component of the SGEIS. There are numerous problems with it. I mean, one could comment on the SGEIS, in my opinion, without even having really read it, just going through the table of contents on all the things that aren't in it. So you could avoid reading it altogether and just come up with things that aren't in it. So if you, which leads into the next part of sort of how to prepare comments. So who should comment? Everybody. Individuals, I think it would be great if kids drew pictures and sent them into the DEC. Business owners, trying to get, the National Chamber of Commerce, don't get me started, but local chambers of commerce, there might be some ability. There are some counties that have convinced that have gotten the chamber to go the right way. So all sorts of organizational type groups. We're blessed here in the Ithaca area to have our fair share of academics. That's terrific. Professionals, municipalities, literally there isn't anyone who shouldn't be commenting on this. On the idea of municipal comments, the deadlines here are going to be short. We still don't even have half the document, but getting a municipality to have the time to send in official comments, it really would be advisable to start talking to your town board now about that, making some suggestions, doing some of the work, with providing samples of other comments and the like, because they all have a ton of stuff to do, particularly when we're haranguing them to pass bans at the same time. So what's the point in commenting? So I did have to put up here, attempt to improve the document, but that's, at least for my money, not the primary reason of commenting on this document. The first is to send an avalanche of comments to more than surpass the 14,000 comments the last time, to send back a resounding message that this is, while there may be some small improvements, that is not nearly enough, that there's just a groundswell of community opposition to this document. Also to try to drive local news coverage, to create sort of media events that get coverage, that highlight for people the problems with this sort of unconventional gas drilling. We all have been working on this months, years. Some people will say they've been fighting this since the Vietnam War, so that it's all the same thing. But there are still people that have no idea what we're talking about and what we're upset about. And getting stories in the paper about this are a good way to do that. So, and then related to sort of the groundswell of community opposition is just slowing down the process. The DEC has to read comments, they have to categorize them, they have to, even if they're not substantive, they've got to put it in a pile, and all that takes time. And they don't have a lot of staff, and time is our friend. It seems like every day, at least every week, you can read about some new study that's come out, some new horrible thing that's happened somewhere else, which is terrible. But to the extent that we have more information, more things that we can point to as reasons why this shouldn't happen in New York, that's really to our benefit. So the purpose of your comments really drives the content. So if you're simply trying to send an emotional message of dissatisfaction, you don't need to knock yourself out reading the SGEIS. You can just send in a comment that you really don't like it. That's not a great comment, but it counts as a comment, and again, it's something, it's a political statement. Again, if you're trying to get news coverage, letters to the editor, things like that, sort of focusing, that's going to be a different kind of comment. And if you are trying to really improve the document and on the idea of slowing things down because you have to read reports and the like, then substance is important, but clearly not everyone is going to have the time or the expertise to read a 1,000-page document and pick it apart. So that's sort of an idea of how to consider, what sort of comment you'd like to make. So it's important in making substantive comments to talk about the things that you support in addition to the things that you don't like, because just as we're trying to change certain things we don't like, industry and other people are going to be writing in with problems that they see with things that we like. So you want to make sure that if there are things that you like in there, that we indicate some support for those. As a legal matter, if you're referring to reports and the like, you have to attach the report in order for the government to consider it as a substantive part of your comment. If you simply make reference to it, they don't have to go out and find it. So if it's something that they've already cited, like the Duke study, or it's a statute or something they have to take sort of notice of, that's one thing. But for reports, you really have to send them an actual copy of the report. Don't expect them to go looking for it. So, and then there's also comments that are geared towards the whole process, what the length of the comment period should be, that there should be public hearings, that certain people have been excluded, that industry's voice is resonant throughout the document, but no one's really consulting with other groups and the like. So those are some ideas there. If you do want to make a substantive comment, you certainly don't need to read the whole thing. You can pick, again, a specific comment or a specific area, or again, one of these myriad of things that don't even get addressed in the SGEIS, so no need to read it. In writing your comments, you want to try to summarize your main points, be very specific in what you want done. It's helpful to include revised language. One of the groups here that's been working, particularly on the mortgage type impacts from this, the DEC came back and said, well, what should this look like? Help us out here. They need help. So if on areas where you really do want it rewritten, and that's sort of your particular interest, including definitive suggestions is very helpful. Highlighting examples, simply saying, I'm unhappy about this, while a good political statement is not as strong as saying, this is what's actually happened in another community. I say I'm concerned about X. Here's an example of where X happened. How would your regulations, how does the SGEIS address this? I don't think it does. Categorize your comments, because they're putting them in categories. So if you're organized, you have bullet points, you can make sure that your comments get put in as many different piles. If your comments are not clear and you have a bunch of sort of, you're rambling on about all these different things, they're just going to pick one comment and put it in that pile, and they're not going to read it for the substance of your other areas. So if you label and organize your comments, you can get them considered in more than one sort of category. And again, sort of active sentences, not using the passive voice, things like, sharp writing is very helpful. These people are reading a bunch of stuff, so if you make it a little more engaging, there's a bit more chance that someone might pay some attention. So for examples of comments, if you go to tcgasmap.org while you're picking out presentations from tonight, you can look at comments from the last round. They collected a whole bunch of good ones. So some of those would be great examples on sort of what comments look like, what did people address. You could even make your own little project. Did these comments get addressed in the revision, if some of those appeal to you? And then where to send the comments. Obviously the DEC, but the New York Department of Health, Governor Cuomo's office, and the AG's office are great places to send the comments to as well. For the DEC, sending the comments in email format is fine because they have to read your comments. But if you're trying to send a message to the governor's office, the AG's office, the Department of Health, an email is easy enough to delete. Packages of mail coming to them on this topic helps make the political statement. And then some addresses. I wouldn't try to write these down now. If you go to that tcgasmap.org, the presentation will be there with these. And that is it. So thank you very much, and thank you.
Thank you, Helen, who with her husband is responsible for many of the bans or proposed bans that are being passed around New York State right now. I would add to the list of where to send comments to your assembly person and senator. We're right now in Barbara Lifton's district, assembly district. She's been an amazing advocate for our side. She has been working on, she has her own bill, on home rule bill, and that's extremely important. And you could certainly thank her for her support. Senator Seward has another version of this bill. We're not sure exactly how those two are going to go together. But so if you're not sure, I believe there are people from a number of counties here. If you're not sure who your assembly representative and senator are, go to the New York State Senate, go to the New York State Assembly. You'll be able to find those. So I really want to thank Helen and all the, there were a lot of legislative comments on the last round that legislators actually sent their own comments. So you can also ask them what are they going to be doing about this document. Every time we've talked to people in Albany, they said, well, we're waiting for the DEC's document, which is their version of shuffling. So now they've got it. We want to know what they think about it.